And with that, Judge, we do not have any further evidence to offer at this hearing. We're going to make, unless counsel does, we're going to make a motion to bind over on the complaint warrant.
We have no witnesses, Your Honor. That court's ready for argument.
Yes, ma'am.
Okay. Your Honor, as to counts 1, 2, well, strike that. Let me begin by saying this. Our exhibit number 1, I feel, is relevant and gives this court some information because it is a photograph of the complainant in this matter at the time that these incidences are alleged to have occurred. And I think that's important because although you have a very articulate young man testifying here, the court also, I think, has to take into consideration who he was back at that time. And I think that picture illustrates that you have a young teenage boy, 14 years of age. I think that's extremely consistent with who he was at that point. So this is the person who's experiencing what is going on, and through the testimony that you heard, that's the person who was experiencing it, not the gentleman that was testifying today. Now, we have charged in counts 1 and 2 criminal sexual conduct in the first degree. We have charged it indicating counts, and actually count 3 also. Counts 1 and 2. Counts 1 and 2 relate to the incident that was testified, which would have been the first indication of, well, strike that. Let me even go back. You heard testimony about the first meeting with Mr. Pugh. You heard testimony about the first time that Mr. Pugh went and picked the complainant up. Now, we put that in there, and I thought it was important, Judge, because one of the theories that we're proceeding on under the counts 1, 2, and 3 is the theory of position of authority and then the coercion causing the sexual contact. The young man spoke with Mr. Pugh with the expectations that he was going to be working with him, or hopefully working with him as an intern, and hopefully working as an intern through the news channel that Mr. Pugh was employed with at the time. It's very obvious from the testimony that came out that there was never an official internship with Channel 2. I think that that's very, very clear. But what also is clear here is that Mr. Pugh, through the testimony that you heard, Judge, put himself out to both the complainant and to the complainant's mother that he was going to be bringing Mr. Pugh in as an intern, that he used the surroundings of his job and the trappings of his job to make it appear that, in fact, it was related to Channel 2. The understanding was that it was going to be he was going to be, he told you, he was going to be a gopher, that he was, in fact, going to be working for Mr. Pugh as an assistant. Now, whether it's official through Channel 2 or whether it's just as a personal assistant, the mindset of that young man at that point in time was that he was going to be working for Mr. Pugh in that capacity. And that he did that, and he saw that as an opportunity to build his resume. He saw that as an opportunity to have as he stated, a successful black man who was homosexual as a role model, as a mentor. That's how he saw Mr. Pugh, and that was what part of the excitement that he got out of involving himself in this situation. Mr. Pugh, or the complainant, indicated that his mother also spoke with Mr. Pugh, and that those discussions concerned the fact that he'd be working for Mr. Pugh in, at least at that point, under the guise that it was an internship with the TV station. That the mother allowed her son to be put into the care, well, basically to go with Mr. Pugh. She essentially put him into the care and custody, in essence, with Mr. Pugh, putting him in a position of authority over that young man, both from the sense that as a person who he would be working for, essentially a supervisor kind of situation, mentality, to the fact that she entrusted him to be with her son. He is put in that position of authority. That the testimony of the complainant indicated that he got to a point where there was, essentially there was grooming going on here. And that's what we saw. It starts with the first contact and the touching of the thigh. It started with coming back and watching a video. And at that point, there had been discussions. Mr. Pugh knew about that the complainant was a gay young man trying to, was a gay young man. And that Mr. Pugh, after the touching, the next incident was not actual full-out sex, but it was show him the video. Do you want to see this? And that also ties into our second theory, which is the enticement and solicitation theory that we're going on. Shows him the video, asks him, notices that that the complainant was aroused as a result of watching this video. That this 14-year-old boy at that point is asked, do you want to take care of that? Mr. Williams tells you that he said, okay. I mean, yeah, there's no twisting of the arm. There's not force in that sense. But, Judge, coercion is not just along the line of force. There is, and the courts have recognized, constructive or implied coercion, that if I don't do this, then something bad is going to happen. And I think it was implicit throughout the testimony of Mr. Williams that that was what that 14-year-old young man was thinking during the course of this situation. So there is the masturbation that occurred. The testimony was that it started out as individual, and then Mr. Pugh crosses the line and makes it mutual, where Mr. Pugh and this young man now are masturbating each other. Now, this is not one of the charges, and we have not, but this is evidence about the grooming. This is evidence about the enhancement, and it's evidence that goes towards the solicitation that's going to come next, at the next encounter. Mr. Pugh, through his words through the young man, tells him, don't tell anybody, I can get in trouble. Once again, building and putting upon the onus upon him that, and it's a coercive onus. Because if you tell, I'm going to not be able to do this anymore. If I tell, my parents are going to be shamed. If I tell, this is going to come out, this is going to derail my thing that's going on with the group that he's in, with Mosaic. And once again, it's that 14-year-old young person that's sitting up, the picture of that's sitting up on your desk there. That's the person who's digesting this information and this process. The coerciveness is building here. The enhancements are being put here. The enticements are being built in here. To the next incident where the young man testified that he goes to Mr. Pugh's apartment, and I believe this is the time to put the desk together, that it is done, and then there is, hey, you want to watch something, and it's a pornographic video, and there is a discussion about the pornographic video. And at this point, Mr. Williams tells you that the first aspect of this is engaging in oral sex, and the second part was engaging in anal sex, that was the subject matter of that video. Now, it goes back to the grooming, because the testimony is that at that point, he is asked, and that's the solicitation, do you want to do this? And he complies and says yes. That the acts that occurred were exactly in the order of which they were done in the video. The young man, Mr. Williams, testified there was oral sex, and then he testified that it was preceded with anal sex, in which his anus was penetrated by the defendant's penis. The after activities that occurred that were testified to that is the masturbation of Mr. Pugh, the fact that the young man was told to manipulate his nipples while that was going on. Once again, this is, and I think it goes back into the grooming aspect, where now we're expanding it. It goes into the coercive aspect in that, like, what can you do? And I think at that point I asked, like, well, why aren't you saying anything? Well, and again, he told this court why. That the impact that it would have and the relationship that he did not want to see in. That's the coerciveness. That's kind of like the sexual harassment concepts of where it goes. That if you don't do this, then this isn't going to occur. Whether it's overt or whether it's kind of a subversive kind of thing that's percolating in his mind. But the evidence is there that this is building, that coercive aspect of it. Then we have, so those, Judge, those are the two, I think I've spoken to the two counts in counts 1 and 2 in our theory of the coercive aspect of it, the position of authority, and also during the commission of another offense, and that being the enticing or soliciting a minor or child for immoral purposes. That the enticing was the showing of the video, and the solicitation was asking for it to occur. So I believe that that theory is encompassed in the evidence there. As to count 3, the allegations there are one of penis into anal opening. The evidence was, too, as to counts 1 and 2, that he was 14 when it occurred. So he was between the ages of 13 and 16, as required by the statute. Count 3, again, the testimony was that he was, again, 14 when this occurred. Count, that would be the, I'm sorry, I think he was, the count 3, I believe he testified he was 15, just barely 15, over his 15th birthday, and that this was the time that he went over to clean the apartment, and that essentially the same procedure occurred. The videos, I believe this one was of Mr. Pugh and someone else. I get these mixed up, but I know that there was testimony, there was video shown, pornographic video shown at that point, and again, a request to engage in, by Mr. Pugh to the complainant, to engage in anal sex, and the complainant testified that in fact his anus was penetrated by the defendant's penis. As to counts, and I would also incorporate my arguments as to counts 1 and 2 about the enticement and the grooming, etc., continuing through to count 3. As to counts 4, 5, and 6, Your Honor, we charge these straight as that anal intercourse occurred and that the young man was under the age of 16. Now, in the front part of the information, we indicated places of offense, and we indicated on Washington Boulevard and at 73 Adelaide. Through the testimony of the complainant, I think it was pretty clear he was 16 years of age when those occurred, so those would fall out. So I'm going to ask that the information be amended to strike 73 Adelaide as a location and rely fully on the at Washington Boulevard address as the location of the offenses. The complainant testified that as to 4 and 5 and 6, that at least 3 separate incidences of anal intercourse occurred at that Washington. And actually, I think he testified to 2. He testified to 2. So as to count 6, I'm going to ask the court to dismiss that. I don't think that we fulfilled our obligation as to that. But he did testify that 2 other incidences had occurred at that Washington address, that he was still 15 years old when they did. He entered into those, and like counsel asked him, yeah, were you forced? No, he entered into it willingly. But once again, and the coercive aspect, I don't even have to, that's not relevant really here, but I think it still was occurring, and it was still in effect. So I believe, Your Honor, that based on the testimony, we've created a question of fact as to counts 4 and 5. As to count 6, I feel we failed to do that based on the age and the testimony of the complainant, so we're asking you to strike. So I'm asking, Judge, for a bind over, and I think that the evidence is sufficient to create a question of fact as to all the elements in this, but to amend the information to strike the Adelaide address and to dismiss count 6. I'm asking a bind over on counts 1, 2, 3, 4, and 5 as charged in the information.
May I, Your Honor?
May.
Thank you. This court is certainly familiar with the standard that's required. And, Your Honor, even though it's a probable cause hearing, there's still a threshold that must be met. And while typically when you have issues related to credibility, it would create a question of fact, I think the court, even at this juncture, pursuant to People v. King and his progeny, can look at the testimony, view the testimony, and determine whether or not it is in fact incredible or incredulous. I submit to you, Judge, that this young man testifies, Mr. Williams says, he doesn't come forward based upon the fact that he feels that he's somehow been harmed. He's scorned. Oh, it wasn't only me. Oh, he lied to me because I thought that I was special. He waits, we're talking about 2003, 2004, 2005, these allegations that have been set forth, and some charges that come in 2016, actually, because he didn't go to the police department until 2015, but the warrant wasn't secured until 2016. Your Honor, it's based upon a motivation of greed and for money. And consequently, in terms of his position, he goes to not the police, not the prosecutor's office, he goes to an attorney to quote-unquote find out what my options are. And it's ironic that it happens to occur at the same time a trial is going on in a civil case. And so he's hoping to get a payday, and that's what this is all about. Once he had received the information that he had to fall within a certain time frame, a certain age, in order for them to proceed, then it became a matter of crunching dates and crunching facts to fit within that time frame. But for the fact of that deed, the court would certainly have continued down Primrose Lane as the rest of us would have also, but for the fact that that deed had entered in August of 2005. So with that, Judge, he would have clearly been 16. Now, 9/28/04 to 9/27/05, he would have been 16. And then 9/28/05 to 9/27/06, then he would have been 17. So now the prosecutor says, well, you know, we get this information, we're not so sure that it happened that way. But look at the testimony. Mr. Williams says, okay, let's jump to count 4. He says this encounter at the mayor's office. When he was on cross-examination, he indicated that it took place within the same year that Mr. Pugh moved to the Adelaide location. Well, that was in 2005. And guess what? He was 16. So now we are maneuvering and trying to say, oh yeah, we'll strike the Adelaide location after all these facts have come out about some relationship at Adelaide that he was old enough to consent to. And so, you know, it's somewhat disingenuous to now say we're going to try to now change these dates when they have information with these dates and times that are not consistent with what has been testified to. It's sad. Had they done proper investigation and not just relied upon the testimony, what facts do the court have to say that it was in 2003 that he was at Fox? Nothing. His word. But we know that the story changed when the deed was presented. So if we have all these quote-unquote encounters that are following along, then it didn't appear that there was some space or span of a year and a half or more where that would have been said, I didn't see him for another year and a half before there was another contact. I submit to the court that it's closer in time than you think, and this young man was 16 at the time of these occurrences. I also think it's ironic, Judge, that here we are with respect to count 2, the count of fellatio, and he indicates, well, you know, I did speak to 3 people and make 3 statements, 3 officers and make 3 statements. No, you know, I didn't mention it. We get here today, the day of the preliminary examination, and now we're hearing about some quote-unquote new encounters. It would have seemed that the prosecutors would have fleshed that out long before today in terms of their presentation of what in fact occurred and where. And so now we have all this fuzziness as far as, what date, what place, and the court might say that it's a question of fact, but I think you can certainly take the testimony as it was presented, because he clearly says that there were some things that occurred on Adelaide. And for the prosecutors to say that you can use counts 4 and counts 5 and just, we're going to be nice, we're going to just, have you dismiss count 6, we don't really have a problem with that. What facts do they have? You can't have a generalization and say, well, it happened on some other occasions without saying what, when, where, how. None of that was elicited from this witness, just to say, yeah, it might have been some other occasions that it happened there. Those are generalizations. Those are not sufficient facts for this court to make a determination of, Judge. And so I'm submitting to this court that the counts 2, 3, 4, 5, and 6, no doubt, should be dismissed. And actually, count 1, and I'll tell you why. 1, 2, and 3, those are being charged in the first degree. Let us look at the theories that the people have proposed. The theories under count 1, the criminal sexual conduct in the first degree, indicates penis to anal opening. But the theories that they're operating under deals with this quote-unquote authoritative position. Judge, he's there just doing work. He's not working at Fox 2. There's nothing that he even did at Fox 2. And aside from him sitting in the car, he would have only been there on one occasion. So there's nothing there where he's using that job to solicit or cause this young man to submit to anything. You have to have an instance where the position itself causes a person to submit. There was no testimony where he used his position as an anchorman to cause this young man to submit to anything. He was gay before he met Mr. Pugh. He wanted to engage in that. Now, if the court says he was young, but we're dealing with a theory at this point. Their theory is that there was some type of coercion, some type of submission. No, there are no facts on this record to indicate that that was the case. And this court, you have to have more than just them saying that. You have to have more than just a person being in power. You have to have something to indicate that that person used that power in order to get something. He indicated that there was nothing that was expected him in return. It was asked, but it was never, if you don't give me some, you know what, I'm going to fire you. He wasn't even, quote-unquote, hired. He's trying to find something for him to do. He put a desk together. He held a bag. Now we want to say he's an intern. Your Honor, please. These tossing out these terms doesn't make it so. And so for them to say we're relying upon this coercion, that argument has no merit. Furthermore, Judge, as they relate to the second theory that falls up under the CSC first degree, this accosting, enticing, and soliciting a child for immoral purposes. That's found pursuant to MCL 750-145A. My argument is this, Your Honor. Now, he wasn't charged. You know why he wasn't charged, Judge? It's because the statute of limitations. And I submit to you, Judge, that if you can't charge a person under that theory, then you can't use that theory to support another allegation, because the statute of limitations would, in fact, have ran as it relates to that. So they're trying to use, quote-unquote, stale information to support a charge that would fall under the CSC statute. The statute was, in fact, amended in 2001 to indicate that certain CSC offenses would extend and have a longer lifespan, but this enticing, accosting, and soliciting was not one of them. And that's their argument that falls up under counts 1, counts 2, and count 3. That being the case, they're relying upon two principles for those three counts. This quote-unquote coercion, which doesn't exist, being in a position of power, that doesn't mean anything. What has to happen is that power has to be used to cause the person to submit to the authority. And that's not what's indicated here. So I would ask the court to dismiss counts 1, counts 2, count 3, based upon the fact that there's insufficient information related to these theories of coercion or submission, and that the accosting, enticing, and soliciting, that's based upon stale information that would not survive the statute of limitations as a result of charges, so it certainly would not survive as a result of a theory to the case. Also, Your Honor, and while I'm at it, while I'm not going to argue today, I do want to preserve it, because I believe that there's some constitutional issues here relating to the statute of limitations, notwithstanding the fact that the legislature did amend the statute, but I think there's still some constitutional arguments that counsel will make down the road, but I'm preserving them today. Also, as it relates, again, to counts 4, counts 5, and count 6, those fall under no particular enticements. The court can refer to the complaint. You don't need the coercion. You don't need any solicitation for 1, 2, and 3. But my basis for the dismissal of those counts is that the information is insufficient, and that while he says that a number of things happen on Adelaide, just striking Adelaide from the information, that doesn't cure anything in terms of the fact that testimony has already been elicited from him of these multiple contacts when he was 16 years of age, which would mean the court would not have jurisdiction. So I would move for dismissal of all of these charges, Your Honor. Thank you.
Well, let me ask, Your Honor, do you have any specific areas that you're concerned with?
Well, I'd like to get the dates straight,
Okay.
because Mr. Williams testified in a manner such that I couldn't sometimes figure out what year we were talking about.
All right.
And how old he was.
All right. Mr. Williams testified that on 9/28 of 2002, he turned 14 years of age. All right. So that would take us until 9/28 of 2003 before we have a next birthday to make him 15.
I'm sorry, counsel, you're dropping your voice.
I'm sorry, Judge. That would take us to 9/28 of 2005 to be 15. 2003. 2004, I'm sorry. Okay.
Start over.
This is getting confusing. 9/28 of 2002, he turned 14. All right. 9/28 of 2003, he turned 15. All right. Now let me just start there. Counts 1 and 2 indicate that the date of the offense was September of 2003. And I believe that was his testimony that it occurred at that period, during that period of time. That would have made him...
Well, Judge, I disagree. I'm not certain that I actually heard him say September 2003. I don't think that's what's based on the record. So,
No?
I'm not certain.
He did give some time references indicating that he first met Mr. Pugh in March of 2003, indicating that he went on a college tour, and that the Mosaic group ended up at one point at Fox to promote their concert, what they call the reality concert. And that's the first time he spoke with Mr. Pugh back in the green room at the Fox 2 station. So if that was in March of 2003, he would have been 15 then, is that right?
At that point, he's still 14, Your Honor.
Well, March of 2003, he would have been 14.
Correct.
And that's when he met Mr. Pugh at the Fox 2 station as the Mosaic group was there promoting their reality play. So, let's see. Then I wrote April 2003, they played telephone tag. The Mr. Pugh came to the Mosaic show. I think I wrote in Ann Arbor and interacted with the group. That Mr. Williams either approached him and jogged his memory talking about doing an internship with them. In May or June of that year, Mr. Pugh came to Mr. Williams' house, spoke with his mom, week later, I wrote a week later, came to his house, but his mom picked him up and they left. I think this is when they went to the MLK march and the side touching started.
Correct.
So at that point,
He's still
this is
14.
still 2003.
Correct, he's still 14.
If it's before September 28th, 2003, he's still 14 years old. He was asked, I'm going to say, at that point, according to my notes, the complaining witness did help Mr. Pugh with his makeup. He made himself useful. That the defendant touched him, rubbed his thigh, told him he did a good job. And that, so this was still when he was 14 years old. He indicated at that point, why didn't he say anything? It's just like, wow, I just want to be I'm going to be on a news story, and I just want to let the thigh rubbing go. I wasn't really interested in pursuing that. Then I need to verify or get some clarification on the next encounter or next sexual encounter when they went to Art Van to pick up the desk and took him back to the Washington Boulevard apartment to assemble the desk. Now, what are the dates on that specifically?
It's during the month of July of 2003.
So I have a note indicating May, June. So the desk incident is when they went back to his apartment. Mr. Pugh put in the Joe Boxer video. The complaining witness gets arrested. Mr. Pugh asked him if he'd like to take care of that. And that's when the mutual masturbation takes place.
Correct, Judge. And that's still not part of the charges yet.
And it's still not September yet.
No.
If I understand correctly.
Correct.
And that's when Mr. Pugh also supposedly, allegedly made the statement, wow, that was good, don't tell anybody, I'll be in big trouble. The complaining witness says that Mr. Pugh looked at him lovingly, and he thought in his mind, wow, I can't believe I just did this with Charles Pugh. He can't get rid of me now. And then a month later, in September, so here we are now in September, I don't know specifically what date this is in September, when they go to the B2K concert at Joe Louis Arena. But in any event, he was either still 14 or he just turned 15 in September of 2003. So after the B2K concert, they go back to his apartment. He's asked if he wants to see a video. And the video is of Mr. Pugh naked on the bed, and the guy comes out of the shower wet. Mr. Pugh allegedly gives this wet guy oral sex, and then I don't know, my notes that said, and is penetrated by the other guy anally, and asked the complaining witness, who could have been 14 or could have been 15 at this time.
Correct. But he's still within the right age grade.
He's definitely not 16 yet.
Correct.
if he wanted to do that and lead him to the bed, ask the complaining witness to perform oral sex on him, and then penetrate him and ask him to, I wrote, lick his nipples as he ejaculates. So the complaining witness is either 14, on the verge of turning 15, or he's 15 years old after this, during this incident. Asked why didn't he tell his mom or anyone. He said he didn't want to tell his mom because she would have taken him out of Mosaic. He and his mom were already at odds with him being gay. He didn't want to be at church all the time. I wrote he didn't want to lose his connection, but became disillusioned. Still felt like the defendant was good to have in his corner, but was somewhat disillusioned. All right, so he went from being a great guy, I think is what he said, to good. So he got a downgrade. But he was still 15. Another time, still at the Washington apartment, he indicated he wanted him to come over and clean his apartment. Why any 15-year-old boy wants to go to anybody else's house and clean their apartment beyond me, other than he thinks he's going to get a quid pro quo, which is access to Mr. Pugh and what he had to offer, helping him with his makeup, or just hanging around with him, hoping to, get a job out of it, or further his own career if he's trying to figure out who he is. He asked him, did you want to do what we did last time? He indicated this time there was no oral sex, but that the defendant put lubricant on him and on his own penis and penetrated him. Now we're up to January 2004. The complaining witness is still 15. And they're going back and forth to small plates for dinner. And he indicated, I don't think there was much specificity when or what they did. But in April, he testified that Mr. Pugh came out of the closet, that he picked the complaining witness up from school and took him to a meeting with Mayor Kilpatrick and other LGBT leaders due to some controversy that had come out publicly. He said he felt really good about having that kind of experience, is what he had hoped to get out of it. He said it felt right. And then they go back to Mr. Pugh's apartment and have sex where the defendant penetrates the complaining witness. He still looked upon Mr. Pugh, he says, as a mentor and looked to him for guidance. He kept hanging out with him because he said, quote, felt it was required or wouldn't be able to work or hang out with him anymore. So, there we have it. Then my notes go to 2005 on Adelaide, that's been stricken. So that kind of clarifies in my mind how old the complaining witness was, at least up till and through the time Mr. Pugh moved or bought the Adelaide address, which we really looked at the deed yet. The warrant, there's a Exhibit A, the defendant's Exhibit A indicates this is a warranty deed between Mr. Pugh and the seller, Carter Oak Homes, conveying, indicating that Mr. Pugh's address is 1431 Washington Boulevard, and conveying to Mr. Pugh 73 Adelaide, and it is signed and dated August 31st, 2005, at which time Mr. Williams would have been still 15. And not turning 16 for another month.
Correct.
28 days here.
No, Your Honor. 9/28/04 to 9/27/05, he's 16.
Well, let me
No,
take a
it's-
look at my,
9/28, I'm sorry.
well, 2005, clearly, Mr. Williams, let's see, August 2000, that's before his birthday.
Correct.
So on his birthday in 2005, he was born in 1988, 12 years, 2000. 12 plus 17. He would have turned 17 September of 2005. He would have been 16 September of 2004. So anything after September 27 of 2004, Mr. Williams would have been 15 years old. Then he would have turned 16 September 28th of 2004. And at that point, he would have been able to give consent. But anything occurring September 27, 2004 and back, he had no legal capacity to consent under any theory.
Correct. Your Honor, and just an aside, just as an aside, all that deed proves is he took title. It doesn't prove when he took residence. And there's no testimony on this record when he took residence. Because you can rent someplace, you can move into someplace prior to buying it.
It doesn't matter.
The fact is that if he took title August 31st, 2005, he was already 16. But he turned 16 September 28th, 2004.
Correct.
So he would have been 16 almost a year by the time Mr. Pugh bought the Adelaide address. So
I'm just saying, Judge, we don't have any evidence that he wasn't living there prior to that, though.
well,
Right, you don't have it.
We don't have it, so, I mean, that deed really, but the bottom line is, and I'm not gonna belabor
well,
it.
you've already indicated you wanted to strike that
That one
Adelaide
count.
and the count that regarding Adelaide.
Correct.
I'm simply trying to figure out what occurred before Mr. Williams turned 16.
Okay,
Okay.
all right.
So he would have turned 16 September 28th of 2004. So after that, he could have consented. Before that, he didn't have the legal capacity to consent.
Correct.
Now I've got my dates straight. Okay, you want to do your rebuttal?
Again, well, as far as,
Well, just a minute. He's already done a rebuttal.
No, he asked for rebuttal. I asked for rebuttal. He said, Judge, do you have any questions regarding anything? I said, I'd like to get the dates straight. Okay. Okay.
and I think the testimony as far as counts 4 and 5, counsel says they're general, but they were specific enough to meet you can see the ongoing pattern, that there was a continuing sexual interaction, relationship essentially with the complainant in this matter. That it began in 2003, and that it continued well into when the complainant was 16, 17. The complainant testified that prior to that, as to counts 4 and 5, during that period of time in which he was still under 16, he engaged with the defendant at the house on or the apartment on Washington, and those engagements resulted in anal sex, which he'd already given the details. And I asked him, were they similar to the ones you described? Yes, they were. He was there subject to cross-examination, but I think you can see from the pattern that this is exactly where it was going and what was going on, and that it continued even after that. I think as far as a probable cause hearing, we've met that burden, and I think it's a question of fact as to the elements in this case, Judge. I'm asking for the bylaw.
Okay. Well, I have written your attention to the one and only witness in this matter, Mr. Austin Williams, and Mr. Williams' testimony is that at the age of 14, he met Mr. Pugh at the Fox 2 TV station as he and his Mosaic group were guests there, and that he initiated contact with Mr. Pugh hoping to either become an intern with Fox 2 or just an intern with Mr. Pugh, but that instead he became his unofficial gopher and sex slave. Basically, he turned a 14-year-old gay boy who admits that he knew he was gay, that he and his mother had some conflict about that, with basically the promise that he would help him by taking him to concerts, having him access to other things that people normally don't have access to, you know, being near him, helping him with his camera work or his makeup. This is all very enticing, and people do worship celebrities, and you don't have to be 14 to understand that people go kind of gaga over celebrities. And for a 14-year-old boy to have this type of contact with a local celebrity of Mr. Pugh's stature at the time was very enticing to him, and was coercive to him. He sits here today, a 27, 28-year-old man, very articulate, but I have to put myself into the mind of a 14-year-old, which is difficult for a 63-year-old woman to do. But looking at the picture of Mr. Williams when he was 14 does help bring things into perspective. So I am going to bind Mr. Pugh over on all 5 counts. Count 6 is dismissed, as Mr. Williams was old enough at the time of those occurrences to consent. No one is saying that he was forced or coerced or kidnapped or beaten into having sex with Mr. Pugh. The fact of the matter is he simply was not old enough under the law to make those decisions. Of course, he made up in his mind that, yes, I'm going to have sex with this man because it will help me. I have access. I've got a connection. This is great. And he already admitted that he was gay. So it wasn't that Mr. Pugh turned him gay, if there is such a thing. He was gay. His mother and he had some disagreements about it. He didn't want to hurt his mother by telling her that he was, in fact, having sex with this man. He didn't want to lose his connections. He thought and processed information like a 14-year-old processes information. Now, a grown person may have been able to resist Mr. Pugh's advances, but at 14, he wasn't able to. He didn't have to. He was 14. He didn't have the legal capacity to consent. And Mr. Pugh took advantage of him, knowing full well that this 14-year-old boy would do whatever he needed to do, Mr. Pugh, to please you. He liked you, he thought maybe you loved him, and he was very disappointed. And that's what 14-year-olds do. They wanted to please, he wanted your connections, he wanted the power that he perceived you to have, and he did whatever he thought he needed to do to keep you on his side. He's bound over. His AOI date is 1 week from today. Ms. Burton, did you wish to address Mr. Pugh's bond, which I believe is currently set at $500,000 cash surety?
That's correct, Your Honor, and it's our position that that bond is excessive.
Pretty much.
There was a report by pretrial services, and they recommended a reduction. They recommended, I believe, $50,000 cash surety or a 10% provision. Your Honor, Mr. Pugh is 44 years of age. 45. My fault. 45 years. He just had a birthday this week. 45 years of age. He was residing in New York. He lived there for about 3 years. Prior to that, he did live on Woodward in a townhouse, and he also lived on Adelaide. His ties are vast in terms of his connection to the city of Detroit. He has multiple family members, one of which is present, his uncle, and some other relatives are here for support. And so he does have ties to this community. There was some indication that he left the state of Michigan. And at the time that he left the state of Michigan, Your Honor, he was under no obligation to report that to the prosecutor's office because the warrant in this matter was not issued until was recommended 6/22/2016. So that warrant for this case wasn't issued until this year. Furthermore, Your Honor, there was a civil matter in which he regularly attended court. That case was not filed until, I believe, June 5th of 2014. And so he left the state of Michigan, but he had no responsibility to tell the authorities where he was going. He didn't have to report to anyone at that juncture. And so for them to say that he left or he fled, which is some of the arguments that they tried to rely upon, that's certainly not true. He moved, but he had free will to do that. And so, but if the court is concerned about whether or not he will appear in court, the court can impose a tether bond. He will stay and remain either with a relative in the Metro Detroit area, or if the court wants him in Detroit, he has another relative that's present in court whom he can stay with and would be willing to also provide that address. And so the concern in terms of addressing bond, the court looks at a number of factors. The court looks at the work history of the individual, in which he worked at JOB from 2004 to 2009, Fox 2 from 1999 until 2009. And he was elected to the city council in 2003, and he was there until 2009, I'm sorry, and he was there until 2013. There's no indication of any substance abuse. There are no physical health problems or mental health problems, aside from the stress of this case. But there's no prior record, no juvenile adjudications, no adult felonies or misdemeanors. And so when you look at the totality of the circumstances and look at the fact, Your Honor, that the charges in this matter stem from allegations that are 12 and 13 years old. And so that in and of itself, he's remained in the community, and they've mentioned some other individuals on which there was no sexual encounters with those individuals, and they were of age. And so with that, Your Honor, we're asking the court to reduce the bond. He will return. With respect to his education, he graduated from Murray Wright High School in 1989 and received a degree in broadcast journalism in 1993 from the University of Missouri. And Mr. Pugh, he will return to court. Judge, I don't minimize the seriousness of these charges, but we're asking the court to be mindful that there's a time in which trial will take place, and he will be prepared for that trial, because based upon the testimony today, the information that has been provided by Mr. Williams, there is a discrepancy in terms of different dates that where things allegedly occurred. I think what's also important, Judge, is that Mr. Pugh needs to be in the community to assist counsel with his defense. And there's some problems because the charges are so old, it makes it difficult. And so, you know, counsel and counsel staff, we're having to try to run and do things, but Mr. Pugh has people that he can connect with and witnesses that it would be better for him to try to locate with in terms of getting numbers and addresses, because it has been a number of years that have gone by, and so he's needed in the community to assist counsel. The residence that he will reside at, there are no minors in the home, and so again, if the court is concerned, then we'd ask you to you know, place him on electronic monitoring or tether. With that, Your Honor, we'd ask you to adopt the recommendation that's been set forth by pretrial services.
May we briefly respond, Your Honor?
Yes.
I got an opportunity to review the bond report and take some notes, because I was going to return the report to the court so that the court had it, so I wanted to make sure I had some notes. And as it turns out, I didn't really have many notes to write down. That is the most skeleton report I have seen in my years here. The word unconfirmed and apparent was throughout that entire report. The writer said I made an investigation. I called stepmom and I called uncle. No return calls, no answer. Mr. Pugh says he'll live on a certain street in a certain city with stepmom. No confirmation of that. So unconfirmed as to that. They noted all their information in terms of their quote-unquote investigation came from Mr. Pugh himself. So we don't know where he's going to live. He also indicated to them, I was currently employed for about 4 months in the state of New York. No phone number, no address. Again, it's for an employment in the state of New York. The investigation found a number, voicemail box full, no confirmation. Unconfirmed employment, and by the way, it's not even employment here. Where he's going to live. They go on and talk about the positive things that show he's a low risk is that he's got some college and, quote, apparent full-time employment in New York. What that has to do with him being a flight risk in Michigan, I don't know. Unconfirmed that he may be able to live with a relative. He has, quote, recent out-of-state ties, and that was one of their concerns. Recent, he's been living out of the state of Michigan for approximately 3 years. Sure, he's got family here, and that's one where I'll actually agree with counsel. Did he have to have any obligation to let the prosecutor's office, the Detroit Police Department, anybody know that he was leaving 3 years ago? He doesn't have any obligation from a police standpoint. But let's think about it. He was the president of city council. Perhaps he had an obligation to let one of them know. I just think that it paints the picture of what was going on then. We're aware that Mr. Pugh left. I won't say flee. If counsel has a problem with that term, he left. It's ties. He has family here. Of course he has family here. Just in looking at MCR 6.106, I'm just sort of going through everything the court has to look in terms of looking at conditions for pretrial release. There is nothing on this list about him being well-educated and access to her client as far as a condition for this court to look at. We've got to look at flight to avoid prosecution. We don't have flight to avoid prosecution, but the court's well aware that Mr. Pugh left while a civil proceeding was going on. So the court can take that in for what it wants. Defendant's mental condition, reputation for dangerousness, seriousness of the offenses, that's very clear from the charges. I don't even need to go into that. Availability of responsible members of the community who will vouch or monitor the defendant. Unconfirmed, not returned phone calls. We don't even have an address where he's going. Availability or facts indicating his ties to the community, length of residence. He's not a resident. He lives in the state of New York. 4-month job there, they haven't confirmed. Nothing here tying him here. Any other facts bearing on the risk that Mr. Pugh will either appear or not appear at the next court date. Those are things the court has to look at. Safety of the community and flight risk. Again, I've said this before. We keep hearing a resume of his education and his past ties. I don't hear anything present, anything that should give this court any indication. To even make a recommendation of a reduction of bond that low that they made in the report. Whether the court thinks the current bond is too high, I think is a separate question. To what they recommended in the report, I think is extremely low given the fact that the investigation was left with more questions than answers. So I'd ask the court to not reduce the bond as recommended in the report.
May I respond, Your Honor? Your Honor, the issues that the prosecutor is concerned about in terms of his residence or where he will stay, his uncle is present in the courtroom. He could either stay with his mom or his uncle, but his uncle resides in Detroit. And I can provide the court with that address, or if the court wants him to stay up and verify that, then it could be confirmed on this record who he can go and live with if that's the court's concern. You know, oftentimes what happens with pretrial services is they may or may not have sufficient amount of time to gather the information. But what does it have to do with in terms of him working in New York? If he's required to stay here, then he will have to remain in the state of Michigan, in the city of Detroit, or state of Michigan, actually, and not New York. If the court makes that as a condition, then he won't leave. And so, yes, when she talks about his obligation to city council, if this were a labor and relations committee meeting, then that might be relevant in terms of him informing the city council. As a matter of fact, he did. He spoke to Gary Brown, who I believe was president pro tem, and it was also an emergency manager that he spoke to in terms of taking leave. And so what the prosecutors don't know, then they shouldn't speak on in terms of what he didn't do, because they should be concerned about, you know, whether or not he will in fact appear in court on this matter, as opposed to just tossing out allegations that are unconfirmed. And if the court wants some indication.
His conversation with Mr. Brown is unconfirmed. I mean, you're just telling me this is not in the report. He didn't tell the pretrial services supervisor, well, I didn't flee Detroit when I was the...
They didn't ask that question, Judge, about fleeing Detroit.
I told Gary Brown.
Judge, that question wouldn't have been posed. It wouldn't have been something that the pretrial services reporter would have been writing.
I'm just saying.
I responded to her allegation.
Mr. Gary Brown knew, but did he tell anybody?
But let me tell you this, Judge, if I can, how about some documentation if they approach the court in terms of when the civil matter started? She said it started before he left. This document indicates that the action was filed. I got the wrong one, I apologize.
Just for the record, Judge, I have not seen any of these documents.
You can take a look at it. You can do the
Well,
same investigation that I do.
I think I've listened to enough arguments.
Your Honor, if I may, I think it's very
No,
important.
you may not. Okay, I heard enough. So, this is the problem. Mr. Pugh was well known in Detroit. It was well publicized, and he unceremoniously left his position as president of the city council of the city of Detroit, and nobody knew where he was as all this civil litigation was becoming public information.
Judge, this is
Mr.
important.
Pugh, and I would agree with the prosecutor, this is a pretty sad pre-trial investigation. Nothing's been verified. The supervisor said that she contacted his stepmother. A second call was placed to his uncle, and neither one of them thought to return the phone call. Maybe they didn't know the importance of returning that phone call, but I bet you the investigator made it clear. I'm calling on behalf of your stepson, on behalf of your nephew. And also the phone number he gave, the mailbox was full. No answer left with his employment, NYG Strategic Marketing. So nobody has verified anything that Mr. Pugh said, and this is employment in New York. So what I have to be concerned about is knowing very little, if nothing at all, about the civil case other than a young male was involved and there was a judgment reached, along with, I think, a settlement with the Detroit Public Schools.
I do have documentation when that matter was filed 6/5/2014.
Ms. Burton, I'm talking now. I listened patiently while you and the prosecutor talked and did your exam across. It appears to me that Mr. Pugh is a gay pedophile. And I don't care that he's gay, that's his business. I am concerned about children and Mr. Pugh being together, especially males, since he's gay. Then he fled the city, and that's how it looked to me. That's how it looked to most of the people here in the city. We know where he was. He had a position of authority. He just up and left. Maybe he told Gary Brown. I don't know. But it wasn't publicized, and people in the city of Detroit didn't say, ooh, wonder where Charles Pugh is. Go ask Gary Brown. Nobody knew where he was until he resurfaced, I believe, I think it was on the West Coast. My memory serves me right. And then again, he resurfaced again on the East Coast once the civil matter got underway. And I'm relying upon my very poor memory. But with regards to whether I should reduce his bond, which is very high, $500,000 cash surety, down to a $50,000 cash surety, that's a big leap of faith that I simply don't have in Mr. Pugh. I don't have the faith that he's not going to bother with some other young boy, because this is what he likes. It's what he, let me put this through. That's what he appears to like. We've got the civil case, and now we've got this case, and I am concerned. I am concerned. So I'm going to reduce his bond, but not down to a $50,000 cash surety bond. He doesn't appear to have any employment. He was working in New York. I don't know if his aunt or his uncle or his stepmother is willing to take him, and that's what you say. And the uncle is here today, and of course, what's he going to say? Sure, Judge, he can come and live with me. I don't even need to ask him that. Of course he's going to say that. Who wouldn't? I got some cousins, I wouldn't want to see them in jail, but would I say, yeah, they can come and live with me so they get their bond reduced? Probably. Probably.
Well,
I mean, that's what family members do. And I'm not blaming anybody, I'm not saying this is a bad thing. That's how family is. My concern is with the safety of the community, the safety of other young boys around Mr. Pugh. Now, if he can make a $150,000 cash surety bond and be untethered, so be it, with a no-contact division with any young male that's under the age of 16. So that's going to be quite a feat. But that's what his bond is going to be set at.
Does the court consider a 10% provision?
No cash surety.
The only thing I would ask,
Mr. Pugh has the propensity to flee when he's upset or scared, and that's my concern, no, not 10%.
I just asked the court continue the order from previously when Mr. Pugh was arraigned. When that bond was set, the magistrate at that point said if he was able to make bond, he's to forfeit a passport and a driver's license to rectify any concerns that if he did make bond, he wouldn't be able to leave
All
the
right, that will
state.
be part of turning your passport, Mr. Pugh, and your driver's license. Should you make that $150,000 cash security, no contact, EPS tethered bond.
Why would he have to turn in his driver's license? He can't drive around the state of Michigan if he was released on bond?
He needs to turn in his driver's license.
Thank you, Your Honor.
Okay.
Your Honor,
AOI date is 1 week from today
I have the orders for,
at 8:30. May I? I need to return your exhibit. Once you work in further.
I know.